It's my privilege to introduce United States District Court Judge Rebecca Pallmeyer. She received her bachelor's from the University of Valparaiso and her JD law degree from the University of Chicago Law School. She was a law clerk for Minnesota Supreme Court Justice Rosalie Wall in 1979 and 1980. She practiced law with a firm for 5 years, then was an administrative law judge for another 5 years. She was appointed as a federal magistrate judge in 1991 and served in that capacity until 1998 when she was nominated by President Clinton to the U.S. District Court for the Northern District of Illinois, and she was confirmed by the Senate and has been a federal judge there since then. It's my pleasure also to introduce Rich Juliano. I've known him since the fall of 2006. Not long after he was sentenced by Judge Pallmeyer, I received a call from a colleague at the U.S. Attorney's Office in Chicago, and she said, "Hank, you know, we know about this program that you have bringing offenders into law schools and business schools. We have a great candidate." He was not only a very important cooperating witness in several recent trials, but he committed his wrongdoing when he was a third-year law student. And for that reason, we think he'd be very valuable to the types of lessons you're trying to share. Since then, Rich Juliano and I have been across the country and made, I believe, more than 24 presentations at this point, from Harvard to Stanford and lots of places in between, letting him tell his story and having the students learn from it. Today, for the first time, we are reuniting the judge and the prior defendant. And I believe, as I said at the outset this morning, that this is truly a rare opportunity for all of us to learn how unethical conduct can morph into criminal wrongdoing, specifically in the political arena, where the intersection of government and politics is inevitable. So without more, Rich, we'll let you lead off by maybe just giving a little bit of personal background as to how you got into the situation you did, and then sort of give us a very brief summary up to the point that you first met Judge Pallmeyer.
Okay, thank you, Hank, and thank you, Judge, for being here, and thanks to our hosts as well, the law school and SLLF. Hank and I have done about really closer to 36 of these around the country, and the first public one we did, which was in February of 2007, was out in the atrium there. That was February of 2007. Coming back to Minneapolis in the fall is much better of an invitation, so I appreciate that. You had a foot of snow, I think, the day before we were here on that occasion. Just a couple of themes here, and sitting through the presentations this morning really address a lot of the different things that we're going to talk about. But themes of what I'm going to discuss, number one being interpersonal relationships, structures of different organizations. What I'm going to talk about, what we're going to discuss, happened in government and in politics in Illinois and the law, of course. And it very much applies to those of you who are legislators, but really could apply to any organization. And we talk about that when we speak to law students and so forth. The importance of mentors and getting the right mentor, avoiding the wrong mentor. And for those of you who are elected officials, what exactly are you delegating to your staff, and how much do you know about what's going on in your political organization or your governmental organization? Secondly, and this has been referenced a number of times, wrongdoing that starts very small and can, in many cases, just be explained away, but it goes on for a long time. In our case, for years, not for months, but for years, with a lot of the same people working together, and the wrongdoing just getting more and more egregious as time went on. So that's another important theme. And I'll also mention that what I will talk about, I mean, the judge presided over 2 very lengthy trials. I mean, she'll tell you about her involvement with all this, and it was a very large investigation, a lot of cases and defendants. I can speak firsthand about my part of it. I was not involved in a lot of the things that she ended up looking at, but my part of it is politics and government, how they mixed impermissibly, illegally, permissibly in some cases. That's what I'll be talking about. So let me just give you kind of the thumbnail of who I am and how I got to this point. I grew up in Cleveland, Ohio. Had the chance when I was a young person to move to Chicago, went to the University of Chicago as an undergraduate first and later on to law school, but was always interested in politics. I did not have any family members involved in politics, which I think is an important point because I didn't have anybody ahead of me who experienced a lot of the things that I did. Had a couple of lawyers in the family, but decided that I wanted to be involved in campaigns, presidential campaigns, whatnot. I was 20 years old in Chicago way back in 1987, and as is often the case, and I think many of you know, and of course we have some Iowans here where presidential campaigning is a high art form, but you'll know that oftentimes presidential campaigns will employ state or local political professionals to run their campaigns in particular states. That's what was happening in Illinois, and I wanted to volunteer for George H.W. Bush, Bush 41 as he was known, and I walked into a campaign office in downtown Chicago, and the first person that I met literally was the person who became my mentor over the next several years, whose name was Scott Faywell. And he was part of a very well-known political family in DuPage County, Illinois, with a number of elected officials and judges and so forth in his family. He was about 10 years older than me and had worked on a lot of campaigns even up to that point. And eventually, and many of you know how this works, volunteering with campaigns. I came in several times a week when I was a college undergrad and eventually attracted his attention, started doing some work for him. Several months later, he was able to make me a paid part-time staff person on that campaign, which was a big milestone for me. And after I graduated, he recommended me for a job in state government in Springfield. And then shortly after that, he became involved with the other big player in this story, who was George Ryan, who had been a state legislator for many years. Was lieutenant governor at that time and was going to run for Secretary of State in 1990. And so Scott was charged with putting together a group of people like myself, younger people, to staff that campaign. And so I joined him in the spring of 1990 for that purpose, working for him full time. Now this is where the story begins in terms of the wrongdoing and so forth. A lot of it has to do with, over the years, who was on what payroll, who was being paid from government funds, who was being paid from political funds. The ideal situation and the permissible situation is if you have a cleaner break there. If somebody's going to start doing campaign work, they go onto the campaign payroll and they proceed accordingly. In Scott's campaigns, and I'm not saying that he invented this mentality, I think that he was, the product of his own upbringing professionally, but in Scott's case, he was always very focused on minimizing overhead costs, payroll costs for the different campaigns that we worked on. He wanted to have a lot of money set aside for advertising. In that first campaign in 1990, this seems very quaint by our standards 25 years later. I think the budget was $1.8 million for the statewide campaign in Illinois, and he wanted to set aside 1.1 or 1.2 for TV advertising and radio advertising at the end. It's many times that now, of course, but at the time, what he wanted to do and what he wanted us to do was to try to keep that non-media part of the budget as small as possible. And so we did things like, he said, well, I'm just going to keep you on the lieutenant governor's office payroll for a little while, but you're still going to be doing some campaign work and things like that. That's really how it started. Mr. Ryan won election in 1990. We ran for re-election as Secretary of State in 1994. I should mention that's a very desirable office in Illinois. It's, I think it was or is the largest Secretary of State's office in the country. because it functions as the DMV basically. So there's a lot of interaction with the public, and a lot of people who have served as Secretary of State have moved up the ranks politically over the years. So that was one reason why Mr. Ryan was very interested in that office and held that office. We were reelected in 1994. A lot of the same things happened. A lot of people doing work while they were on government time who should not have been doing work at that particular time, either on particular occasions or on more of an organized basis. And then a couple things happened as we moved to the late 90s. And again, this is a lot of us working together through the years, a lot of the same people interacting and so forth. So as we got to the late 90s, a few things happened. Number one is I took a break from the political world and the governmental world, at least full-time, and I went to law school. So I had a chance to go to the University of Chicago Law School, back to my alma mater, starting in 1995. I did maintain a part-time relationship during that time with the Ryan organization, worked as a part-time legal researcher for the lawyers who worked at the Secretary of State's office, did various tasks for them on an occasional basis as needed. In 1997, after I had finished 2 years of law school and was looking at my last year, 97, 98, and taking the bar and getting all that over with, the incumbent governor announced that he wasn't going to run for re-election. He was not going to run, so Secretary Ryan, then Secretary Ryan, was the obvious choice, at least publicly in the media and the political world, to be his successor. Certainly the front runner among Republicans and really the front runner among all possible candidates out there. So Scott was the one charged with, again, putting together that organization. I don't mean charged in a legal sense, but basically that would come up later. But basically that was his task. And he was the principal staff person, and many of you are familiar with people like this. He had control over the Ryan political organization, but also the governmental apparatus at the same time. And that's an important part of this story, because some of you may say, well, you know, how could some of these things happen? And again, he had very complete control on the staff level over both of those aspects of it. So we had a number of conversations about what I was going to do during this campaign. He was calling a number of us in who had been part of the Ryan operation over the years and said, look, this is our big opportunity. We're going to run for governor. Let's talk about what you are going to do as part of this. And we talked about a number of particular job duties where I was more or less going to serve as his deputy during the upcoming campaign. I told him, look, I want to finish law school. I want to take the bar next summer. I think I can do those things and still be involved very much with what you're doing in coming months. And then when that's over next summer, you will have all my time until the end of this in November of 1998. He wasn't particularly happy about that answer, but he agreed to that. And then we talked about how I was going to be paid in the short term, and this is kind of an important point here. And I said, well, why don't you put me on the campaign payroll on a part-time basis? I can do what I need to do for you. I can go out and do political activities and events and won't have to be worried about who finds out about it and that sort of thing. He said, no, he said, we can't afford that yet. I'm going to get you another part-time contract with the office. So I agreed to do that. And we can talk later maybe about the rationalization, what I was thinking at the time. A lot of things went into that thought having to do with where I was at that point. It may look like a black and white decision right now, and this is what Hank was referring to when he was saying third-year law student and so forth. But you have to remember the things that came before it over many years, where Scott often talked about, well, this is Illinois. Illinois is a very political state. The line between government and politics is not really the same as it is in other states. The other side is doing it. We all know that the Democrats control the city and county government. They do all these kinds of things as well. And as long as the media doesn't find out about it and we end up with a bad story about any of these things we're doing, it's not going to be a problem. Let's just win the election and everything else will take care of itself. It's the ultimate ends justifying the means. So I agreed to this arrangement thinking, well, I'll go to school when I need to, which I did. and I'll do the political activities, which I'm expected to undertake, which I did. And this government stuff, which I'm supposed to be doing for this part-time contract, I'll figure out a way to get it done, and somehow we'll work it out. Well, realistically, there wasn't any chance to do all three of those things. I didn't do the government work I was supposed to do. And that arrangement went on for about 4 or 5 months, resulting in about $22,000 that I ended up with that I had not worked for properly. But again, there was compartmentalization. That's the political world, that's politics, that's Illinois politics, what I was learning in law school, you know, professional responsibility. Of course, I'm never going to commingle funds or steal from a client or anything like this, but this is a different set of rules of engagement. That was the rationalization. Anyway, there were other things going on. I won't go into the details of them, but there were, you know, payroll falsifications that people were doing. There were use of office supplies and office equipment that belonged to the government that was being used for political purposes, a lot of other things like that. And then many other dimensions of this case, again, that I think the judge will address that, you know, thankfully I was not involved in directly as far as the Ryan organization was concerned and the campaigns and so forth. So we won the election in '98. I served in the governor's office for a while as a deputy chief of staff. From my standpoint, personally, the wrongdoing ended there with the election. There were, again, other things that ended up going on, but not involving me. I had the chance in 2001 to move to Washington, D.C. I was appointed in the Secretary of Transportation's office, working for Secretary Norm Mineta, who was the only Democrat in the Bush 43 cabinet, so it was a great honor for me. I worked there during 9/11, 2001, and participated in the activities relating to that, which obviously was a very tragic but also historic time. And really, that was the favorite job I've ever had, was in that position, having the opportunity to do that. And by the way, I was, at that point, a lawyer, had passed the bar in Illinois, and subsequently waived into the bar in the District of Columbia as well, where I was working at that time. So, in the summer of 2001, I was contacted by a lawyer who was doing some work for Governor Ryan, who was in the second last year of his single term. He also announced around that time that he wasn't going to run for re-election because there was an investigation going on that had started out with bribery in these driver's license facilities back in the 1990s, and people getting licenses who shouldn't have gotten them. And as often happens in these investigations, and you've heard a little bit about this, it went off into a lot of different directions. And eventually they started looking at, the federal prosecutors, the FBI, started looking at how were the Ryan campaigns conducted in the 90s, how were they paid for, what were people doing. They interviewed hundreds of my former colleagues. And a lawyer who had done some work for Governor Ryan called me and said, and I was at the Department of Transportation at the time, and he said, well, you're probably going to get a call from somebody at the FBI about this. And he basically just downplayed the importance of the whole thing. He said, I don't really think there's anything there, but if you do get a call, you're going to want to get a lawyer and get somebody who understands the U.S. Attorney's Office in Chicago. So I did that. I lined somebody up back in Chicago who I had known casually before, and I was eventually served with a grand jury subpoena a couple of weeks later, and that basically just set off a process where this lawyer and I sat down with the prosecutors. And what did I find out? Well, I found out they knew a lot. So, we've been talking about in the social media presentation, who knows what about what you're doing and so forth. And in politics, loyalty is very important. You harbor a lot of confidentialities and secrets and so forth. And that was certainly the case with all of us. Well, I found out that this group of people in the federal building knew a heck of a lot about what we had been up to for several years prior to that. And eventually what happened is the decision came down to, did I want to cooperate in this investigation or not cooperate? And moving to DC had been an eye-opener for me because I encountered really a much higher level of professionalism among the people that I worked with, a clear line between politics and government. A lot of it's written into federal law, certainly, and it's made very clear about how all that works. And I just wanted to put those previous experiences behind me not thinking at the time that I was going to be prosecuted, because that didn't seem to be an option that they were considering, as long as I told the truth. So I agreed to cooperate, and to make a long story short, there was a new U.S. attorney, kind of a new way of looking at this in the fall of 2001, and they came back to me and said, well, we think you're telling the truth, we think you have a lot to say to us, but you're going to have to work out a plea agreement with us on at least one felony count as part of this. That is the right thing to do. After thinking about it, talking to my wife, talking to other people who counseled me, and an additional lawyer, because why not have two lawyers instead of one, you know? So I had one in D.C. and one in Illinois to help me with this. I did decide to do that, decided to cooperate. And where I'll leave the story right now is we're now in the spring of 2002. The government is charging Scott Faywell, my former boss, with multiple felonies, including racketeering, charging Citizens for Ryan, which was the campaign fund, the entity, which, you know, many of you have entities like that you're associated with racketeering, and then myself with one count of mail fraud for the improper use of some office equipment back then, but also a plea agreement that involved a number of other activities that I admitted to in there along the lines of what I've told you about. And the agreement was that when we got to sentencing, whenever that was, that I would be able to argue and my lawyers would be able to argue for whatever sentence we thought was appropriate. We did not stipulate or agree to a particular sentence. That's April 18th, 2002, because it was my wife's birthday, so I remember the date, and that's where I'll leave the story.
Well, Judge, it's a good place to start with you. You've been on the bench, the district court bench, for about 4 years at this point, but I'm guessing this was by far the highest profile case you'd received on your docket up to that point. And why don't you tell us your reaction to being assigned the case and having Rich Juliano come in and plead guilty, and then a broader view of the role of the courts in ensuring that our government processes are law-abiding.
Well, it was a case I got early on in my career, and actually there were a couple of indictments. An indictment of Mr. Faywell that went to trial, and then later an indictment of then Governor Ryan and a dear friend of his, a man named Lawrence Warner, a businessman who was indicted with him. These people were charged with racketeering. There were a number of other guilty pleas as well. Judges feel differently about high-profile trials. Some of us think, hey, this is fun. I'm not one of those people. In fact, my husband can remember this story because when I actually got the indictment of George Ryan, you know, the word was on the street that Ryan was being investigated. Ryan was in the sights of the United States Attorney's Office. Ryan was going to be charged. There wasn't any mystery about that. Everybody knew what was going to happen. The only question was when, what would the charges be, how serious would they be, and which judge would get it. When the case came to me that morning, I called my husband breathless. I said, I got Ryan. And we are part, it was to the fall, and we were part of a family gift exchange, and I have a nephew named Ryan, and he thought I had drawn Ryan in the gift exchange. And his reaction was, yeah, we can live with that. We'll buy him a jersey or something. It'll be all right. No, I mean, I got the governor. Anyway, so it really was very tense. It was a case that was in the spotlight all the time. The trials themselves were long and arduous. Mr. Juliano testified at both trials, the trial involving Scott Faywell and the trial involving Mr. Ryan. The trials got a lot of attention from the press, and most of what they reported was accurate, but the emphases were all off. So they would become excited and hysterical about something that was very routine. So that's a whole story to itself. But what we're talking about is what resulted in, what brought those charges to the court. And originally, as Mr. Juliano mentioned, there was a concern about this licenses for bribes scandal. And word was out that you could buy a CDL, a commercial driver's license, which, as you can imagine, I'm sure here as well as in other states, is a valuable commodity. You want to be able to drive across the road, and you need a commercial driver's license to do that. In the Secretary of State's office, it became clear that people were getting commercial driver's licenses who weren't entitled to them. A complete sideshow, but became kind of central, was that there was a terrible accident, truck accident in Illinois involving the Willis family. Willis was a fundamentalist minister, had many, many children. 6 of them died in a fiery crash. It turned out the truck driver who hit them had gotten his commercial driver's license by way of a bribe. That was one of the things that popped up in the investigation. And the bribes, it turned out, were being given, at least there was a sense that they were being given because the people, the rank and file, we're not talking about people at your level. We're not talking about people at the Faywell level or the Juliano level. We're talking about people that were just rank and file employees. But these people had pressure to raise money for the campaigns. Another whole story. You know, we can talk about that practice. But when you're a $20,000 or $30,000 or $40,000 employee of the state's attorney, of the Secretary of State, and you have a family to feed, you really don't have a lot of ways of raising money. You don't have a lot of money yourself, and you may not have a lot of friends that have a lot of money. You're not a person who can be a bundler. You're just an average person. One way to get that money is that when people step up to the counter and say they want their CDL, you can maybe ask for a little bit extra. And that practice became very widespread. A number of people pleaded guilty. Others simply gave testimony in return for immunity. But that's where it began. And from there, the prosecutors learned about other methods, other ways that employees were being pressured, including, we need some assistance on the campaign. Can you help us out? Can you help us out on the campaign this weekend? There was even a period of time where, for reasons that I never quite understood, somebody does, it turned out that the Ryan campaign was helping the Phil Gramm campaign in Iowa, and we had Illinois employees going to Iowa to help the Phil Gramm campaign. Now, in fairness, I think that was going on weekends. I don't think that was actually on government time. But I don't know how genuine political interest on the part of public employees is. Maybe they feel strongly that their boss is the absolute best thing that could possibly happen for the state of Illinois. Maybe instead they feel a sense that they need to keep this person in office for job security reasons. Under any set of circumstances, it is not right to pressure government employees to be involved in politics. Maybe this is routine, maybe it goes on all along, all the time. But you know, the taxpayers are paying government employees to do good government work. That's what they're paying for. So for them to be having allegiances shifted in another direction seems just really obviously improper to me. Anyway, Ryan, and first Faywell and then Ryan were charged. There was testimony from dozens of witnesses. The trials were so arduous. Mr. Juliano was a centerpiece of both trials. It turned out Faywell, who was charged, found guilty, and sentenced first, ultimately gave testimony in the Ryan trial as well. But in his original trial, there were, as I say, dozens of witnesses, Secretary of State's office employees, who testified about their activities while they were working for the Secretary of State. And it was extremely disturbing, as you can imagine. One of the memories that I have was how disillusioning it was for me personally. You know, there are lots of jokes about Illinois politics. I can tell them myself. Right now, we're looking at a terrible budget problem that was generated really because of bad government and political decisions that have been made over the years. All of you who are from other states can say, hey, we don't do things like that here. I mean, I get all that. I get all that. For me personally, I'm living in a state that I'm proud of. I know that there are many wonderful people in government in Illinois. And I'm amazed that this kind of thing was going on and really chagrined by it. And what bothered me the most in the Faywell trial was I heard, again, dozens of witnesses testifying about the pressure they received to take a day off and go work on the campaign, or to do other things, or to use properties and equipment that belonged to the state for campaign purposes. And how many of them simply felt, this is the way we do it here, this is the way it happens here. I may not like it, but this is my job. I was told to do so by somebody up above. And I think Mr. Juliano's right that it's not necessarily always the person absolutely on top that's in charge. you people that are running your offices may not have any idea what everybody else down the line is doing. But somebody might be exerting some pressure. And what bothered me the most was how few people felt they could say no. No. I heard out of 40 witnesses, I heard 2. One said, no, I won't do this. Did not get any particular repercussions, but didn't get a raise when raise time came. One person said, okay, I will go work on the campaign for you, but I think I have to take vacation time to do it because that's not really government work. One person who actually said to their boss, you know what, this is government, I'm being paid by Illinois, so no, I can't work for the campaign while I'm being paid by Illinois. And I really found it disturbing that a culture had been created, not only in our state generally, but in this particular campaign and office that led to this incredible abuse. Now, the Ryan, we're talking about the Fawell trial right now. The Ryan trial involved some other aspects of the corruption, including when Mr. Ryan was Secretary of State. He was already governor, but he was charged with some conduct that he'd engaged in while he was the Secretary of State. Most of the conduct was as Secretary of State. And there were tax charges and racketeering charges. And one of the things that he did that was central to getting him convicted was his good friend Larry Warner, a businessman, owns lots of properties in Illinois. And if you're the Secretary of State, again, it's an important office in Illinois. Mr. Juliano is correct. It's very prominent. The Secretary of State controls a lot of properties because there are a lot of buildings at which people get their driver's license tests done, and there are other facilities that are owned and managed by the Secretary of State as well. So when some of the property is leased by the state, some is owned. When the lease would expire and it was time to consider, are we staying there, or are we going to move someplace else? Well, if you have a friend who's got a vacant building who really is having trouble unloading it, that might be a great place for the Secretary of State to move its operations. So that's the kind of thing that happened. And proving a violation of the law in that context is very difficult because you have to prove, the prosecutors in that case had to prove that this was not the highest and best use of the property, it was not a reasonable rent that was being paid, and the officials and their cronies, their colleagues, knew this and were doing what they were doing to benefit themselves as opposed to benefiting the public. And that theory is the theory of violation of a public trust or use of public resources for private purposes. You might have noticed before when, you probably didn't, I mean, I feel people aren't paying attention to me, but when we took the vote early on about would you send this person to jail or would you give jail time to that person or that person, I didn't vote on any of them. Number one, I don't ever give advisory opinions on cases, so I wouldn't do that. But sentencing is really a complicated matter, and there isn't a single sentencing situation that I think can be summed up in a few words and we can decide what to do. We always look at a very substantial pre-sentence investigation report, and I did that in Mr. Juliano's case after he pleaded guilty. I did that with Mr. Fawell. I certainly did it with Mr. Ryan. People send letters. You get character letters. Mr. Juliano got something like 100, but there were 78 that were actually in the record. People that write to tell me what a terrific person this is or why I should be sympathetic or why I should be lenient. Sometimes it's letters to the reverse. Sometimes it's letters saying, here's how I was victimized by this man's crime. Please send him to prison. Or this woman's crime. Please send her to prison. But more often you look at a number of factors and considerations in making a determination about whether prison time is appropriate. And in Mr. Juliano's case, the fact that he cooperated early, that he cooperated without any promises given. In fact, even before he was indicted, in other words, he wasn't making any deals at the time that he began cooperating, that his cooperation was forthcoming and that his testimony was so valuable and was so completely forthcoming was a big factor in my decision to sentence him to probation. But that's a hard call because the sentencing guidelines for Mr. Giuliano were pretty severe, as they are in these cases. The guidelines, you don't want to. It's a book that you don't want to read. It's a big, fat, large book. But it's amazingly sensitive, and it includes considerations of all stripe: the nature of the crime, the nature of the individual involved, the amount of money involved, the person's role. Were you somebody who recruited others? Were you recruited in? Were you a relatively low-level participant, or were you more or less what we call in the, in the trade, a kingpin? All of those considerations are factors, and there are a number of others as well. And then there are personal factors. But back at the time that I sentenced Mr. Juliano, the law was that the guidelines were not guidelines. They were straitjackets. So if I got a guideline range of 78 months, I imposed 78 months. The only exception back then, things have changed now, but back then the only exception, the only way a judge had the authority to impose a below guideline sentence was if the prosecutor made that motion. Prosecutors are great people, but some of them are, as we say, 28-year-olds blessed with the truth. So we're putting an enormous amount of discretion in the hands of very young, very smart, but very young people. Now, it happens that the prosecutor who was involved in Mr. Juliano's case, I've known him now for years, was not only a very young and smart person, but also wise, and I think sensitive. And I think his recommendation for what we called then a free fall, we call it a free fall departure from the guidelines, meaning free fall means, Judge, we, the government, are moving that you depart from the guidelines, but instead of telling you how much, we're going to let you choose yourself. So that's the best deal you can get, and that's what Mr. Juliano got, and I think he deserved it.
Judge, maybe that's a good point. Let's have it go back quickly to Rich Juliano and let's talk about the sentencing. And as I have read the transcripts, the judge asked you at one point to share things that she had heard that you had learned from this whole process. And I think they apply far beyond just this case. So talk about the sentencing and those lessons that you would share.
Let me first mention, to put this in context, that when we did the plea agreement, which took effect, had to do with the plea in April of 2002, one of the things I agreed to was not to seek sentencing for myself until all related trials and investigations were over. Typically, between a plea and sentencing, it's a matter of months, I think, Judge. I think normally something
Right.
like that.
Right.
In my case, it was 4.5 years. Because we had, as Her Honor told you, we had the Fawell trial, which didn't start until the next year. That went on for several months. And then when that was completed, then former Governor Ryan was indicted, and that took a long time to get to trial because there were some issues with counsel's availability and that sort of thing, and that was another very lengthy trial. So he was not sentenced. Former Governor Ryan and his co-defendant were not sentenced until the fall of '06. And I was advised by my counsel, just wait until all those things are done. Let's go by the agreement, and then there's a better chance you're going to sort of be focused on individually in this situation. So it was not until October of 2006, October 10th to be exact, that we had the sentencing hearing. I had cooperated extensively. I had testified in both trials a total of 10 days in the judge's courtroom, which I was told was many days compared to most witnesses that you see.
True.
Between those two trials, and had many different sessions with the government, with the prosecutors and the investigators behind closed doors prior to that time as they developed their investigation in both cases, and some other things that they were pursuing, again, that were more peripheral to me. So we did prepare for that time to come before the judge. A number of people did write letters and were very supportive. And I would mention about that as well that I think a number of them emphasized the point that I had accepted responsibility and that I had recognized my wrongdoing from the past and was trying to ensure that maybe some good came of that at that point. So I think that was an important point that many of them made. But in reflecting on my experiences at that time in the previous few years, I came up with sort of 3 aphorisms, and it actually relates to a number of things that have been said here this morning already. But one is more or less the red flag test, which is if you are told by a superior or a colleague, whatever it is that we're doing, it's the other side is doing it, or we have to do it to stay competitive, and it's particularly true in politics. And or it's always been done that way here, or this is how we do it, and so forth. That should be a red flag. It doesn't necessarily mean that what it is wrong, but it means that you should try to step back and get some perspective, or maybe talk to somebody else from outside of your sphere. And that's something that we did not do over those years. That was actually discouraged to do that sort of thing. Secondly, and Hank said this explicitly earlier, you have to assume that everything you do is going to be scrutinized. Of course, now more so than ever, than in the time that we were talking about, there was no social media, there was very little internet, all that sort of thing. But the fact of the matter is, your decisions are going to be scrutinized, and so you should be prepared for that. That doesn't mean concoct a paper trail to try to cover up what you're doing or deciding. But the law enforcement, the media, the bar examiner, the securities examiner, the IRS, whoever it is, could end up taking a look at what you're doing, and you have to be prepared to defend that and to be confident about that. And again, thirdly, something I did not do, and very few people did who I worked with at that time, if you're continually confronted with these moral and ethical dilemmas, find something else to do. Withdraw yourself from that. And I can go on again about my decision making, why I stayed with that organization at that time, and that's probably a story for another day. And again, there are complexities to it. It's having been conditioned to think a certain way over so many years, having worked in that environment. But I tell people, particularly at the law schools where we speak, you're going to be a lawyer, you're going to have a license, you're going to have options, you've gone to a great school, you can always find something else to do, and believe me, in the long term, that's the right thing. And a corollary to all this is about telling the truth. And again, this was mentioned earlier. I had a number of colleagues at the time who admitted to, and this was part of some of the charges in some cases, destroying evidence, lying to the grand jury when they were brought in, shredding bags of documents, that sort of thing. Thankfully, it never crossed my mind to do anything like that, and I didn't do anything like that back in those days. But there were others, including at least one who was a law student like me at the time. He was not ever charged, but did do some things like that. You certainly can make things a lot worse by behaving that way after the fact, and this should not be this should be an uplifting story in a way, because of the chance I had with the judge in her sentencing and what I've been able to do. We can talk about that in a minute, what I've been able to do in my career since then. But I attribute that to telling the truth, because I think if I had been making up stories, if I had lied, been charged with perjury, any of those sorts of things, I think that my second chance in my career would have been a lot less likely.
Well, one thing I'd like you just to add as a postscript, Rich Juliano, as was typically the case, lost his law license when he pled to that felony. Not only lost his dream job, but lost his law license. But that's not the end of the story. Tell them what's happened in the last few years.
Well, going back to that, I resigned my federal position. The people there were great. Secretary Mineta himself was very supportive of me, but it was not appropriate for me to stay there while all that was happening. So shortly after that, I was fortunate enough to go to work for a trade association in D.C., a National Trade Association. I am still with them now. Started with them in April 2002. I've been with them continuously ever since then. I did surrender both of my law licenses, the ones in Illinois and in D.C. After a very, very lengthy, another lengthy process, I was reinstated by the Illinois Supreme Court in the fall of 2013. And was very gratified. You have to go in front of a hearing board, and then the regulator, the ARDC, appealed it, and we went to an appeals board, and both of the opinions were very complimentary of me and some of the things I've done over the years since all of this happened. So that was very gratifying for me. And then just this last spring, I was reinstated in D.C. By the D.C. Court of Appeals in a similar, shorter process, but a similar type of process. So that's good news from our standpoint.
Judge, we heard earlier from Doug Kelly about whether prosecutors hold elected officials to higher standards. And I would ask the same question of you. Do the courts hold elected officials, people in positions of public trust, to higher standards? And should they do that with other similar officials, whether they be corporate leaders or church officials and the like? How does a judge view the citizen who has positions of public trust when they come before them?
The judicial oath calls upon the judge to do justice to the rich and to the poor equally. In other words, you don't get a pass because you're a rich person, but you don't get knocked over the head either. Now, with respect to a public trust, the sentencing guidelines themselves include a enhancement. We use the word enhancement of your sentence for a violation of a public trust. So, the Sentencing Commission, which is established by Congress, itself sees that role as somehow important. Let's take the church leader. You mentioned that earlier. We think of church leaders as having particular power over their members, and we think sometimes of those members as being then vulnerable victims. So if a church leader, for example, were to take money that belongs to a parishioner, we might think of that parishioner as a vulnerable victim, and that too would be an enhancement of the sentence. Whether public officials are held to a higher standard otherwise is kind of a prosecutorial decision, because it might be that prosecutors decide, I'm going to make an example of this person. I'm going to demonstrate to the world that just because you're a big shot doesn't mean you get away with this, and therefore I'm going to come after this person for something that I might not prosecute somebody else for. Or just as Mr. Juliano mentioned, there's another law student who may be involved in some misconduct, and the prosecutor makes a decision not to indict that person. Maybe because he wasn't as prominent, and therefore was not as important an example to set for the public.
How about questions from the audience?
I guess just to fill in some blanks for me, Judge, how did you become a judge? Were you appointed by a certain, this was a district judge?
Yes. Appointed by the president. I was appointed by President Clinton in 1998. Before that, I had been a magistrate judge, so I'd been in the courts for a long time, but I had not been a district judge handling felony trials for very long at that point.
Do you think, were you selected for that trial? How did that happen?
That's a very good question, and the answer is that no, it's random. And that's why it was really a shock. In fact, before the indictment came down, again, all of us were talking about it. Everybody knew George Ryan's likely to get indicted, and people would ask, you think you'll get it? And I always said, well, my chances are 1 in 22, because there are 22 of us district judges in Chicago. It's a fairly large federal court. But no, it's random.
I actually was never sure about this. The Faywell and the Ryan cases were...
That's what it was such a surprise.
That's
because
what I had thought.
They are related cases in a way, but Faywell came to me off the wheel. We say the wheel, which it's just a reference to a random assignment. And Ryan came to me off the wheel, so it was kind of a coincidence.
That's the part that puzzles me in terms of the question, because it would seem that those two cases being not related but related, to fall to the same bench would be interesting.
Well, it was too much work.
It actually was a great benefit to Mr. Juliano, too, because the judge got to see him twice under extended cross-examination by some of the best defense lawyers in Illinois. And I've been through trials like that. I would say that this judge knew more about this defendant than most judges ever know in trying to pass the ultimate fair sentence.
Probably knew more about my work environment in the 90s than my wife did back then, with all the different personalities.
Ma'am?
Everybody.
I really appreciate this segment and Pallmeyer. And the question is for you, Mr. Juliano. So you're reinstated with your license and practice law. Whatever happened with your felony? Do you still hold that felony?
It's still on the record. It still is. I mean, I think the only one who can ever remove it is the president through a pardon.
Are you trying, moving in that direction as well?
Maybe someday that would happen. It's a very remote possibility, I think, particularly in recent history. The pardon process has come under a lot of discussion. Different presidents have handled it differently. There seems to be more of a an inclination not to do as many pardons now, at least for someone sort of in my situation. So, I don't know.
Well,
That's a little bit like lightning striking, probably.
I just want to say, you know, we all have constituents with felonies who are doing the right thing as you've done, and so your story just provides proof.
Thank you.
And in the state level, there are so many movements underfoot, both legislatively and with the help of the courts, to try and address those felony records through expungement and the like. The problem at the federal level is that the way that the laws are set up, it really does take a pardon from the President of the United States.
So, you know, we haven't spoken about the specific charge to which Mr. Juliano pleaded guilty, but one of the things the campaign did was purchase a copy machine. They needed a copy machine, and they used state funds to do that. So it was a one-count felony mail fraud charge because the mailing of that invoice is considered a violation of the law.
We also haven't mentioned, just quickly, the sentences that the judge imposed on Mr. Faywell and former Governor Ryan. And my recollection is they were both in the range of 6 years imprisonment. And those were obviously very strong messages. I want to take your question, but I'd also like the judge to comment at the end here what impact, if any, her sentences she thinks has had on Chicago or Illinois government practice. But sir, go ahead.
So as I'm listening to this, I'm thinking about the complication of politics and campaigns. And because of our current campaign system and structure that we have in place relative to politics, it seems that we continue to create more and more and more laws to try to sort of narrow that gray area down to make it black and white. And this is probably a political question as much as anything. Isn't there a possibility that if we did public funding of campaigns, that would do away with a lot of these things that we have that go on, that, you know, have it so that staff, you know, within, you know, governmental agencies are asked to do things for campaigns, author books and stuff like that. I mean, it just seems that we've created a system that there's a myriad of ways to fall in and do things that seem like, well, yeah, that seems okay to do that. And later we find out it's not okay.
Well, yeah, I think that's a complex question. It would help, I think, more in the area of the independent expenditure phenomena that's taken over a lot of campaigns. If you have incumbents or even just state officials who are running for office, who have access to state employees and state resources, even having a publicly funded campaign wouldn't prevent them from trying to get an advantage by having stuff done on the side if they had the power and the inclination to do it. So I would sort of respond, it takes cases like this to send the message that the consequences of doing that can be very severe. Judge, has the climate changed in Illinois?
Well, you may have heard of Governor Blagojevich, who was charged with the misconduct with which he was charged was quite different. He was famously charged, did all kinds of things, but famously it was alleged that he tried to trade his power to appoint somebody to Barack Obama's vacant Senate seat for some kind of favors or money or something. So, but there were all kinds of other things, and he ended up getting a very much more severe sentence, which has been vacated on appeal, but is likely not to change much because what the Court of Appeals did in his case was to reverse certain of the convictions, but not the major ones. So I suspect he'll still be serving a lot of time in custody. I do think people in Illinois recognize that you get involved in corruption, you can go to jail for it, and I'm that's a positive thing. It's when you get down in the weeds and explain exactly what was going on, what people were doing, that I'm not sure they were so clear on that, because I don't know how many people. Nowadays we have our news on the internet. At that time people were more reliant on the newspaper. I'm not sure whether they're reading every detail. I'm not sure people are getting every nuance about exactly what was wrong or why. What troubled me, among many things, what troubled me was the notion that the taxpayers are paying somebody to work at the state of Illinois driver's license facility, or a more exalted position at the McPier, the Metropolitan, our organization that runs our Navy Pier. And are they We taxpayers are expecting that whoever hires those people is going to hire somebody who's really great for that job and really knows how to run this or that, or really knows how to, be an effective public servant. Not someone who happens to be there because he or she runs a campaign. I mean, it's not even good government. It's bad government. You don't get the best people for the job if their qualifications have nothing to do with the job requirements. So I don't know whether that lesson has gotten through. And I still, of course, I'm a federal judge. I still have cases all the time involving government decisions that, in the little villages and towns that surround Chicago, the police department gets into a dispute with the mayor and somebody gets fired, and then that person, maybe defrauds somebody else. There's a lot of corruption, I think, misuse of public funds that is still not being detected as it should be.
Rich Juliano, any final thoughts?
Don't get into this situation, believe me.
One of Mr. Juliano's rules that I tell people all the time, there aren't any secrets. There are no secrets. Whatever it is, someone is going to find out. And if for some reason there's a secret and it stays with you to the grave, it's still not worth living with it.
Yeah, we did not think that way at the time. We were, in our organization, our political organization, we were taught to be very insular, to, if anything, sort of denigrate the advice of others. And there were, I think, people from time to time who tried to tell us sort of the wise men and women in the political community who maybe came to one of us occasionally and urged us to step back and think a little bit of a different way. But again, I never had the benefit of attending anything like this or hearing a speaker like myself talk about the real world aspects of this. And again, how they can start out small in a situation maybe when you're just beginning your career. And there was something that in Mr. Hansen's presentation last night, if it's good enough for the boss, it's good enough for everybody who works for the boss.
Right.
And that was very much the way we used to think back then. If he says it's okay, then it must be okay. If he's never gotten in trouble for it, then we won't get in trouble for it. That's very much the case. I think just in being here today and listening to the different presentations, I think you're committed to a higher form of ethics, and hopefully that's what we'll see.
Let's show our appreciation to our speakers. So that ends the public portion of the program. And the legislators, we look forward to hosting you for lunch upstairs. It'll start in about 25 minutes or so in the room right above where we're at. And anybody who hasn't gotten the tickets yet for the Twins game, please see Libby Myers.